The impact of the recent NLRB decisions on employers in the area of social media has been significant. The NLRB is not going to tolerate, it's made it very clear in its decisions, that it's not going to tolerate vague language that would seem to prohibit what they call concerted activity or activity they want to protect. For example, discussing workplace conditions or your wages. Companies need to be very mindful if they're engaging in any decisions of a disciplinary nature, whether it's to admonish somebody even, dock them, suspend them, or go so far as to terminate them. If they're basing that adverse employment action, that disciplinary action, on something that the employee did in social media, they need to be very mindful of what the NLRB has recently done in the last year. So for example, if an employee is on Facebook and complaining about, the workplace conditions and saying that such and such employer, runs an unsafe shop, right? Or they're paying everybody below market, right? And that violates technically that employer's it violates that employer's policies with respect to disparaging the company. You have a general policy saying you can't disparage the company publicly, which used to be okay, now is not okay anymore under these recent NLRB rulings. You want to talk to a lawyer first. So advice number one for companies about social media policies is to definitely have one. Advice number two is to make sure you run it by a lawyer who understands this area well. A social media policy that would have been likely considered acceptable by most in the employment law community a year and a half ago is not going to be considered acceptable today. So this is definitely an area where the law is in flux. Again, that is always the case with technology. Technology races faster than the law does, and the law is always catching up.